So with that, I'm pleased to introduce our speaker today, Terry Bertram. He's a founder and lead attorney of the Legacy Law Center in Ann Arbor, has been providing estate and elder law planning services to families in the greater Washtenaw County area and beyond for over 30 years. His expertise in managing the financial, personal, and legal impacts of incapacity and death has helped thousands of individuals and families preserve millions in life savings, avoid nursing home poverty, and protect their legacy. He's going to be talking on the importance of keeping estate plans updated and the necessary steps to assure solid planning for elder life, as well as protecting one's legacy for family members and or designated recipients, and any other topics he may come up with. So with that, I'll introduce Terry Bertram. Thank you.
Thank you, Roger. I now understand what it's like to be part of a warm-up band when you're waiting for the feature presentation. I, too, can't wait to listen to Barbara, especially after the last week or so. But I digress in there. So I'm fortunate enough to be an estate planning attorney in this community and recognize several people here that I've had the privilege of working with. And I'm going to try to not bore you with this topic. And I think a place for me to start is often what our office hears from consumers calling us. Oftentimes, we will hear people call and they ask us about, I need a will. And we go, okay. And their second question typically is, how much will that cost? And that is because that's their only framework to deal with this. And like a good attorney that someone said, our answer is, it depends. But often what I talk about with folks is that's the wrong question. That's the wrong question. That may be a more important question might be, what happens if I don't die and I need to deal with things at that point where I need to transfer decision making and what have you? Our probate court has more cases that are filed and dealt with for individuals who are incapacitated and there are no decision makers for them. Because often when people come to us, they say, I need a will. Well, guess what? A will isn't going to help us if we happen to become incapacitated. And with modern medicine as it is, that we're living longer, we're more likely to go through a period of decline where we need helpers. And unfortunately, most of us wait until we're in a crisis to deal with that. And I'm a strong believer that it makes more sense to prepare for that when you're not in a crisis, so that you have your ducks in a row, if you will, prior to that occurring. And as such, to me, and not diminishing, having that will or that trust and dealing with who gets your stuff when you're gone, but, when you get on an airplane and they take you through the safety drills before you go up in the air, one of the things that we often hear, if we're listening, to the flight attendants is when the oxygen mask comes down, put it on you before you put one on that child or anyone else. Because if we don't take care of ourselves, we can't necessarily take care of others. And that also goes into this arena here. We've got to make sure we take care of ourselves so that perhaps we're preserving a legacy for others. And also making sure that if we are in a situation we have caregivers, that it's as easy as possible for them in dealing with an awful situation. And so what are some of what I refer to as the tools that we all need to have no matter what our situation is? And to me, there's three that we need to consider. One is a comprehensive, and I use the word on purpose, comprehensive financial power of attorney. This is a document, a tool that often someone will try to conjure up at the last minute and put together, and it doesn't do what it needs to do. Now, a traditional simple power of attorney is, okay, I appoint so-and-so, and I want to make sure if I'm unable to, they pay my bills. Keep the utilities on and what have you. Yeah, that is important, but what if I have a need for long-term care assistance, and if they had the authority to reposition my dollars, they could qualify me for long-term care assistance sooner without me doing a spend down of all of my money. Do we want that authority in our power of attorney in case that becomes necessary so that our spouse doesn't go to the poorhouse or we're able to leave a legacy as well as being taken care of well? I would think that most of us would want that in our powers of attorney there. And so those things become important. And also we want it to be up to date so that third parties accept it. Oftentimes people will look at what we have, and when we present to them, they'll go, Terry, this is way too long. There's too much stuff in here. My life is simple. And what I try to impress upon folks is, although your names are on this power of attorney, our audience is not you. The audience is the financial institutions, the government agencies, the healthcare providers, and the outside world, that they will accept it when whoever you've appointed as your helper needs to use it. And if it doesn't respond in a way that they will accept it, then we have a problem. And so that I use the word comprehensive in that way. And in the other way is what we have in our business sense today may not be what's in our business world later on in terms of things that become important to us there. Down the road, you know, we may need to pull some equity out of our home in order to pay for our care or for other things. And we want to make sure that there's the authority to do that. I had a situation where a family had, it was previously a farm, but quite a few acres there. And while mom and dad were well, they split off a few acres and provided that to their children so that they could build a house. And mom had the audacity of getting sick and becoming incapacitated. And there was one child yet who hadn't gotten that split off for them, and dad wanted to do that. Well, they attempted to, they had the survey done, they attempted to do a deed, and the title company said, sorry. on your deed, it has on there both mom and dad, husband and wife. And therefore, both of them have to sign off on it. And you can't sign for her because she's incapacitated. You don't have the legal authority to do that. And she's incapacitated now. She can't give you that legal authority to do a power of attorney. So what do you have to do? You have to go to court and seek to have what's called a conservatorship. A conservatorship, as our local probate court judges like to remind us when we try to go in there and just get it done fast, this is the only legal proceeding other than criminal law where we're stripping the civil rights away from someone and giving it to someone else. And therefore, even though it's family members, they can't cut corners. And we wouldn't want them to cut corners if it were us who needs to be the protected person. And furthermore, there are very specific rules that the court must follow. And one of them is you can't take assets away from a person. So therefore, in that situation, he was not able to provide for that other child to split off the acreage. And we've had that situation where sometimes they need to sell rental properties and to pay for care in that. And they can't do it because they don't have the authority in place, thinking that, well, since we both own it, either one of us can deal with it. No, that's not the way things work. One of the largest assets that most of us have that is cash versus real estate is our retirement plans. I don't know how many times I've had someone come in and say, oh, I already can access my loved one's retirement plan because they put me on as a beneficiary. Unfortunately, a beneficiary is only if there's something left after your death on who gets it. It does not give that beneficiary any legal authority during your life to access that, should that be needed. And so you want to make sure in that comprehensive power of attorney that it gives you authority to pull dollars out of your loved ones, IRA, 401k, TSA, whatever your retirement plan is, should that be necessary to provide for your health, your living expenses, your family's living expenses, and what have you. Now, the other thing is, in terms of that being accepted, is in Michigan, the laws have changed regarding powers of attorneys. They changed in October of 2012, and more recently, July 1st of 2024, just this past summer. Now, does that mean if I have a power of attorney that was done prior to the July 1 of 2024 that it's obsolete and has to be replaced? No, it does not have to on that basis because it was done prior to that. Rather, you want it to be looked at, and if it was done prior to October 1 of 2012, the question is whether third parties will accept it. And I tell people, if it's prior to 2012, you've got to have it updated there. But the 2024 changes, they specifically grandfathered it in. Now, some of us may want to have an update because of that law. The new law that was created, it provides certain requirements not only for that power of attorney on who it is who's creating it, but also for what we call the agent, who would be your helper. And they have to sign an acceptance, and that acceptance lets third parties, the financial institutions in particular, off the hook for them having to make decisions on this. And if someone does something bad and dastardly with your power of attorney. And that becomes important to make sure it's accepted by the banking community, the mutual fund community, the broker community, and what have you, when that time arises. The other part of the new law is it was passed on what is called the Uniform Power of Attorney Act. And uniform means that this is around several states, and now Michigan is one of 32 states, including the District of Columbia, that has passed this Uniform Power of Attorney Act. So that if you go to any of these other jurisdictions and you want your power of attorney to be there, used and available there outside the state, it now works in these different jurisdictions. Unfortunately, for us snowbirds, Florida hasn't become one of the Uniform Powers of Attorneys Act states yet, nor has Arizona become one of the powers. While there's 32 states, there's a few that I have a sense of a lot of popularity, but it's not happened yet with those. But they have legislation that's been introduced, but it hasn't passed at this time. But that's critical, that you look at that document and make sure it works. The other one on the flip side, and the one that I'm much, much more passionate about, is a healthcare power of attorney. To make sure that we designate people who can make medical decisions for us if we can't make them for ourselves. And at least as important, that we say within that document what we want or don't want regarding end-of-life, life-sustaining treatment. This is an area that we pretty much uniformly ignore. We don't want to deal with it. But the last time I looked, the statistic hasn't changed too much. 100% of us are going to die. Now, we can say what we want, or we can wait for the crisis to occur and say, let it get figured out at that time. May I suggest that it's important, and it's important that we have critical conversations with our loved ones, because I have seen a lot of attempts for us to put healthcare powers of attorneys together that will express all of what we want or don't want, but they are all inadequate. I had the wonderful opportunity of consulting with the University of California, San Diego, where they got quite involved in going to the different states and putting powers of attorneys together for healthcare, and worked with them on one for Michigan. And it's better than some, but it still doesn't really do justice for what becomes necessary. And to give you a couple of quick stories in this vein. So I had a couple, and they have been pretty clear that when the time came that they wanted to switch from treatment to palliative care to hospice care if necessary. Her husband was failing, and she went out to the grocery store quickly, and while she was gone, the person who was taking care of her failing husband got scared and called an ambulance, and he was taken to the hospital. That happens. This was on a weekend. And the people who deal with you in a hospital are called hospitalists. And the hospitalist says, well, my job is treatment, treatment, treatment. I've never helped someone to die. And I liked her answer. She said, I've never helped my husband to die either, but that's what we're going to do together this weekend. Well, I understood her passion and desire, but the hospitalist was quite concerned on whether he had the ability to do this, and she had the right documents in place. They had those crucial conversations, and she was able to force the issue of them bringing in another physician from a hospice program to help her and help her husband to die a dignified death from their viewpoint and not from the hospitalist's viewpoint. I had a younger brother who unfortunately got diagnosed with brain tumors with a very, very short period of living of 2 months. In his dying process, he wanted to die at home, but he was afraid to because he goes, it may be ghoulish to my family if they view where I have this bed and I die in it and there's a dead body that has to be removed. And those were his fears, but he didn't want to talk about that, thinking that that would be horrible, although everyone knew where the end was going to be. And I was able to facilitate that crucial conversation to make sure that he was at peace, knowing that that would not be awful for them, and that it was important to them also that he be with them as he went through that dying process. There are a couple of sources of information that I suggest people consider in this area because there's no way the legal document is going to give us the information that we need. The one that started me on this path of becoming more passionate about it is, I'm sure a lot of you have heard about, is Being Mortal by Atul Gawande. If you haven't read that book, it's an amazing book, and there's a physician here at U of M who's the head of one of the centers. He's the one who talked to me about it, said it changed how we do business here at the university because of what it had to say about death and dying and what we ignore. As far as how we prepare ourselves for the inevitable. You know, am I more interested in a good life or a long life? Would I prefer to be in a hospital setting or in a home setting? Is palliative care and hospice care something that would be what I want or don't want? Do I have religious needs and beliefs that I would want people to make sure that I can participate in? Do I have music or other things that are important to me during that time? There's an attorney that I know, he says, look, I want to make this real, real simple for everybody in my family. He says, as long as I still like chocolate and college football, keep me going. But if either of those are out, pull the plug. It doesn't matter anymore. It's important that we all have lifetime planning in place. There's a couple sites that I like people to look at and consider, because there's a lot of good information for us to have these crucial conversations with our loved ones. One is called theconversationproject.org. Theconversationproject.org. That is a place where you can get a lot of good information as to how to have those critical conversations with our loved ones. And by the way, I don't suggest you do this on Thanksgiving. And the first thing you have to do with these conversations, too, is help. No, this doesn't mean something's happening to me tomorrow. I'm doing this so that when that inevitable occurs, we have had those conversations ahead of time. The other one that is, to me, quite helpful, there's a website called whenyoudie.org. Whenyoudie.org. And also provides, that one is a video for family to help facilitate having a conversation about these things that we never want to talk about there. But again, this helps you appreciate that when we get that phone call, people say, I need a will, how much is it going to cost? It's only because those are the only questions we know to ask there. Now, having talked about what we do while we're alive and helping ourselves to avoid going to court to have what's called a conservatorship, it's handling our money, or going to court because no one has the authority to make end of life or other medical decisions for us. That's called a guardianship, and avoiding that. As to who gets our stuff, we can use a will-based plan or a trust-based plan. A will-based plan is, as I refer to people, our engraved invitation into the probate court process. So often people say, well, I'm avoiding probate because I have a will. And I go, well, it doesn't quite work that way. When you have a will, it has to be, to become effective after your death, admitted by the probate court. And as a result of that, assuming it goes smoothly, the court issues a court order to who you've appointed to be in charge of your estate, the executor, if you will, and in Michigan we call that person with a will a personal representative. But all wills must be probated. It is not your way of avoiding probate. It is your way of going to probate. The vehicle that you use, if you're interested in avoiding probate and having the maximum flexibility for your loved ones, and that I'm a strong advocate for, is the use of a trust, often called a living trust or a revocable living trust. And that is a vehicle you create during your life. And think of it as you're creating a bucket to hold your assets. You create this trust, and then you put your assets into that trust there. Now, what does that mean? Am I giving up control? Absolutely not. So my spouse's name is Maria. So we have a trust, and so the name of that trust is the Maria and Terry Bertram Trust. Now, the people in charge of a trust are called trustees. We're both the trustees, so it's Maria and Terry Bertram, trustees of the Maria and Terry Bertram Trust. So that's what goes on the title of our assets or the beneficiaries of our assets. But everything either is put into the bucket when we create the trust, or automatically goes into the bucket after our death, or we have named beneficiaries on our different assets, because we want to make sure in any event that there's a place for these things to go, because if there's no place for them to go, they're subject to that will, or if we don't have a will, to what's called intestate proceedings, which are all before the probate court. And one of the things that I can guarantee you, and us attorneys tend not to guarantee a whole lot, and we like to use weasel words like that might work, or that should work, or it depends. But one of the things that I can guarantee you is our probate court judge does not get a piece of the action. They are on a salary, so they don't have any vested interest in having more probate matters before them. They're pretty busy on their own, and they are stacked up there, and so they're not looking to get your situation where they are handling that either during life for those conservatorships or guardianships or after death there. And in fact, a retired probate court judge, in talking to us attorneys at one point said, I believe the most important documents from my perspective on the bench is the financial and the healthcare powers of attorneys to first eliminate what happens during life in terms of problems, and then look at what happens to our stuff when we're gone. But we want to make sure that in any type of plan we have, we are providing for a smooth succession of key decision makers. And with the trust, we have successor trustees who are named in case we become incapacitated, as well as upon death. And then the other thing is, with a trust, unlike a will plan where if I'm 18, I get it, and I don't know about your families, but I can speak to myself. When I was 18, I was technically an adult, but I was financially immature. Some might say I'm still financially immature, but at least at age 18. And with a trust, you can protect beneficiaries as long as possible, where you can dole it out or have someone else in charge of it, a banker, if you will. And otherwise, you can provide or allow for family members to grow into their inheritance so that it's not something that's provided as a lump sum. So if I take a swing at the bat where I get some now and I mess up and screw up, I've got something coming later, and maybe I've learned from that and can do better the next time. So that's a little bit of my overview, and I'm supposed to stop yapping at this point here and give you an opportunity to ask any questions at this point. And again, there's mics on each side. If anyone has a question there, I'd be happy to see if I might be able to help you with an answer.
Thank you. Wow, you're a treasure trove of great information.
Well, thank you.
So what, basically, I know you can't answer in detail, but what would you suggest for a non-traditional or blended family that wants to develop a trust? Would you suggest 2 separate trusts or what? Thank you.
Thank you for your question. That's a great question, and it's one that we work with a lot and are proud of working with different scenarios there. And this is one of the times I'm going to use that weasel word. It depends. I have had situations where it's not so much what the situation is between partners or what have you, as much as what they want to accomplish. Are the assets kept separate, or are they commingled? Do they have the same beneficiaries and decision makers and people they want to be in charge, or are they different? And even in, you know, a husband and wife situation, at times they want his and her trust. It's not unusual that it's a second marriage, or, we'll have same-sex partners or other non-married relationships where people may have their assets separate, but they may also, in those scenarios, have a shared asset or a shared objective, where maybe one of them owns the home, but they want to make sure that should they be the first to die, that their partner has a roof over their head, and do the type of planning that will make sure that that's included. And then we want to make sure that we're answering the questions: who's responsible for, the taxes and the insurance and the maintenance and upkeep during that time there. So it takes planning whenever there's mixed families, but it's something that is done all the time and possible. But I can't tell you a single or a joint or a two trust or one trust. It really does depend on the circumstances.
Just two quick comments. Number one, when I did my financial power of attorney, I was very amazed to find out that TIAA and my credit union both wanted to review the documents before they would approve them. So if you haven't done that, they need to see them. Number two, one of the things that helped me with my planning for the end of life was a document called 5 Wishes. And I love 5 Wishes. My sister and I both did that, including what we want to really tell our relatives that they needed to hear. Even allowed to tell what kind of music I wanted. Third thing is a question, and that's about, I've got a will. I've got beneficiaries on all my accounts. I've got, I want to put somebody on my house deed. Why do I really need a will? I mean, I don't have a big estate. I don't have, and I've already got beneficiaries on everything. Is a will needed? Is a trust needed? It just seems like it's an overkill.
Good question. Sometimes it may be an overkill there, but part of what I try to help people in making those decisions is I use an analogy. I have homeowners insurance, and it seems like the only one who's winning on this is the insurance company. But on the other hand, I'm not going to cancel my policy and go without. Because in the unlikely event, and I know it's unlikely, but if there's a fire or a flood, I want to know that I'm protected in regards to that. And what I find in terms of relating that to my world, it is amazing on how after a death, assets percolate up that nobody addressed because they were attempting to do estate planning by asset. It's a very difficult thing to do and to keep straight, and oftentimes they say, well, I want to be fair, so I'm going to put, Jimmy on this account, Susie on that account, and this one I'm going to put both of them on, but there's this $5,000 life insurance. I'm only going to put one person on there because I hope they take care of my burial needs at the time of my death and what have you. And it gets crazy to try to do that and go, maybe you should have that all together so it sings together and not attempt to do that. And also, when we and how we put people on assets, we want to be careful because often the way that I see that it's done, I go, oh, well, you may not have meant to do this, but you've also volunteered to the IRS your willingness to pay more taxes than you were otherwise required to. And there can be gift taxes if the thing that would put someone on is greater than $18,000. There can be capital gains tax. If I inherit real estate upon death, I don't have to pay any taxes on the growth that there was by the now deceased person. But if that person during life puts someone on that real estate during life as a co-owner, they do get it at your death. That does work. But it also means that they have to pay the capital gains tax on the difference between what was paid for and what it's worth at the time of death there. And we don't want to necessarily volunteer to pay any more than we are required to pay in terms of taxes there. So good question. There's a lot of variables in that.
I just wanted, my husband and I have a living trust. We've had it for a number of years, and I just wanted to add my voice to the choir in terms of, you know, if any of that sounds intimidating, it's such a relief knowing that our kids, if something happens to both of us, that they don't have to go through probate. But I just did have a question, or maybe it's a clarification, because my understanding is with the right documentation, if both of us were to get into an accident and die tomorrow, is that with the right paperwork, they could go to our credit union account and actually get funds out. I just thought, the other thing I wanted to mention is, by the way, we had this done by signing up for the legal program through the U of M benefits. I also wanted to mention that.
As to your question in terms of if something happens, and neither of the original trustees can act on the trust because of incapacity or death, and you've named successor trustees, can they immediately act on behalf of the trust? And the answer is yes. And by immediate, I mean, it's not the same 24 hours. I mean, typically, if I say at my death, once I pass, it goes to so-and-so, they have to prove my death by way of a death certificate, and that can take a few days to get. But it's rather immediate versus court, which is typically, you know, the quickest you're going to do that is more than a month away, and the fastest application of that.
My question relates to the power of attorney for health and
Okay.
how enforceable it is, you know, based on your wishes. One example I would think is a very common thing for hospitals to do with a person who perhaps has had a stroke and is to get a gastrostomy tube in and take them to the next level of care. So if you have specified no gastrostomy tube, how enforceable do you think that would be? And are there ways to make it more enforceable?
Yeah. That's a good question. And in fact, after I impressed upon you having a power of attorney and having these crucial conversations, U of M actually did a study of people coming through the emergency room, and of those who had powers of attorneys, how often were they seen to begin with, and how often were they honored? And unfortunately, the number was below 50% there. And depending on sometimes the philosophy or the religion of the hospital, it can, depending on what you want or don't want, it can be even less than that. But here's what I have found in those situations. If there first is a healthcare power of attorney on there, and if it does give authority to the person you have selected, which in Michigan we call a patient advocate, and if someone has gotten more of an intervention than what was desired, that instead of just listening to the attending physician or the hospitalist saying, well, I'm sorry, we did this, we can't undo it, that you request to go to their ethics committee immediately, and they will do that, you know, at that point to attempt to get what is desired. But it is critical there because I don't know how many times we've had a family member who flies in at the last moment, who hasn't been involved, and all, no, stop, this is what we want. Oh, Lord, help me here, and stuff like that. And so we want to make sure we have the right authorities in there as well as things like that. But these, I will tell you, I wish that there were an easy answer. There's not an easy answer to deal with this issue of how we die. Is all we can do is make sure that we're having these crucial conversations ahead of time, and we've documented who's got the authority and what their authority is in broad terms, because if you try to specify, this instance, it's more values conversations, not, a specific as to healthcare decisions in a narrow sense, but in a broad values sense, then you're going to get where you want to be a lot easier.
Something came up to me. I had done a trust a long time ago, and things changed. And I think people sometimes get complacent, and you don't realize you totally need to redo it because it's too out of date with technology. And that I never even had thought of that till my attorney said to me, you need to have your will and your trust all updated. Mm-hmm. Just a comment.
Yeah, so the first date on trust that I did was in the late 1980s. And I look at some of those now, and I go, what is this? And I'm the one who wrote it. So we call that a restatement, where there's been so many changes. Back then, it was really bare bones. It was new to the industry, and it was the consumer who was forcing us into this, and we didn't necessarily know what we need to put in there. And so what a trust looks like today versus what it looked like back then, there's been a lot of evolution on things. And I always suggest to people, because our own situation may change, the laws may change, and also as to what the outside world will accept, where we have our assets and what have you, changes on what they need to execute your wishes there. You should have it reviewed every 3 to 5 years to make sure that it works now. It's not a static document that you do 25 years ago, you throw it in a corner and you forget about it, and you'll use it again at some unknown date, and that's it. I want to thank you folks for your attention.